Welcome to Supreme Court Opinions. In this episode, you'll hear the court's opinion in Rudisill v. McDonough. In this case, the court considered this issue is a veteran who has served two separate and distinct periods of qualifying service under the Montgomery GI Bill and the Post-9, 11 GI Bill entitled to receive a total of 48 months of education benefits, without first exhausting the Montgomery benefit in order to obtain the more generous Post-9/11 benefit. The case was decided on April 16, 2024. The Supreme Court held that service members who, through separate periods of service, accrue educational benefits under both the Montgomery and Post-9/11 GI Bills may use either one in any order, up to the statutory 48-month aggregate benefits cap. Justice Ketanji Brown Jackson authored the 7-2 majority opinion of the court. Section 3322D, which discusses coordination of entitlement, does not apply to veterans like Rudisill, because he already has two separate entitlements and is not seeking to coordinate or convert them. Further, the election mechanism in Section 3327 is optional, and Rudisill does not forfeit any entitlement by declining to make this election. Finally, the consequences of making a Section 3327 election, as outlined in Section 3327D, only apply to individuals who actually make that election, which Rudisill did not do. Therefore, Rudisill retains his two separate entitlements, subject only to the overall 48-month cap on total benefits. Justice Brett Kavanaugh authored a concurring opinion, in which Justice Amy Coney Barrett joined, expressing concerns about the justifications for the veterans' canon of statutory interpretation, which favors veterans when interpreting ambiguous statutes related to veterans' benefits. Justice Kavanaugh questioned whether such a canon is consistent with the practical realities of the legislative process and the judiciary's proper role in interpreting spending laws. He suggested that the court may need to address the justification for this and other benefits-related canons in a future case. Justice Clarence Thomas authored a dissenting opinion, in which Justice Samuel Alito joined, arguing that under the plain text of the statute, Rudisill's post-9/11 benefits should be limited to the amount of unused Montgomery benefits he had at the time he elected to switch. The opinion is presented here in its entirety, but with citations omitted. If you appreciate this episode, please subscribe. Thank you. Justice Jackson delivered the opinion of the court. Petitioner James Rudisill first enlisted in the United States Army in the year 2000. Over the next decade, he re-enlisted twice, serving a total of 8 years on active duty. As a result of his first period of military service, Rudisill was entitled to 36 months of educational benefits under the Montgomery GI Bill, to be paid by the Department of Veterans Affairs, VA. Rudisill's subsequent periods of service separately entitled him to 36 months of educational benefits under the Post-9/11 GI Bill. Both of Rudisill's entitlements were subject to a 48-month aggregate benefits cap. Rudisill used 25 months and 14 days of his Montgomery benefits to help fund his undergraduate degree. Then, after serving his third tour of duty, Rudisill sought to use his post-9/11 benefits to attend divinity school. The VA informed Rudisill that his post-9/11 benefits were limited to the duration of his unused Montgomery benefits, pursuant to a provision of the Post-9/11 GI Bill. In other words, according to the VA, by requesting post-9/11 benefits before exhausting all of his Montgomery benefits, Rudisill could receive only 36 months of benefits in total, not the 48 months to which he would otherwise be entitled. The question before us is whether Rudisill can access his post-9/11 benefits entitlement without being subject to the durational limit. We hold that he can. Because he simply seeks to use one of his two separate entitlements, the durational limit does not apply. The United States has a proud history of offering educational assistance to millions of veterans, as demonstrated by the many GI bills enacted since World War II. Post-9/11 GI bills honor the sacrifices of those who have served in the military, and as such, have a positive effect on recruitment for the armed forces. These education benefits have also helped to reduce the costs of war, assist veterans in readjusting to civilian life after wartime service, and boost the United States economy. In the more than 75 years since Congress passed the first GI Bill in response to World War II, it has enacted additional GI Bills, most of which share two relevant features. First, an individual with the requisite period of military service becomes entitled to educational benefits, typically in the form of a stipend or tuition payments, which the VA is then required to provide once the veteran enrolls in an eligible education program. Second, with one brief exception, GI Bills from the Korean War onward have provided education benefits to fully qualified service members for a fixed duration, 36 months of benefits. Per GI Bill, up to a total of 48 months of benefits for those service members who become eligible for educational benefits under multiple GI Bills. This case relates to the overlap between two recent GI bills. The first is the Montgomery GI Bill Act of 1984. The Montgomery GI Bill provides basic educational assistance to service members who first enter active duty between 1985 and 2030. Montgomery benefits give veterans a basic educational assistance allowance that helps meet, in part, the expenses of subsistence, tuition, fees, supplies, books, equipment, and other educational costs. This limited stipend ordinarily does not pay the full costs of a veteran's education. As with other GI bills, the Montgomery GI Bill consists of a detailed series of statutory provisions that include an entitlement and also durational limits. To be entitled to basic educational assistance under the Montgomery Benefits Program, a service member must satisfy certain military service requirements, typically 2 or 3 years of continuous active duty. The service member is then entitled to 36 months of Montgomery benefits. An eligible service member may make an election not to receive Montgomery benefits, but unless he opts out, he contributes $1,200 into the program, usually through a series of pay reductions. The Montgomery Bill's 36-month entitlement is also subject to a provision that limits the aggregate period for which any person may receive assistance under 2 or more GI bills to 48 months. The second GI Bill at issue in this case is the Post-9/11 Veterans Educational Assistance Act of 2008. When it enacted this bill, Congress expressly recognized that service on active duty in the armed forces has been especially arduous since September 11, 2001, and that the Montgomery GI Bill's modest educational benefits, which were designed for peacetime service, had become outmoded. Therefore, the Post-9/11 GI Bill gives service members enhanced educational assistance benefits that are commensurate with the educational assistance benefits provided to veterans of World War II. A service member entitled to Post-9/11 benefits ordinarily receives the actual net cost of in-state tuition, additional public-private cost sharing to cover the cost at private institutions, a monthly housing stipend, a lump sum for books and supplies, and additional amounts for other specified expenses. As with the Montgomery GI Bill, the Post-9/11 GI Bill establishes an entitlement and also prescribes durational limits. To be entitled to Post-9/11 benefits, service members must typically serve on active duty in the armed forces for at least 3 years starting on or after September 11, 2001. An individual entitled to educational assistance under the Post-9/11 GI Bill is entitled to 36 months of enhanced educational benefits, and as with Montgomery benefits, this entitlement is subject to the same provision that limits a service member's aggregate benefits from the Post-9/11 GI Bill and other GI bills to 48 months. Because the Montgomery and Post-9/11 bills cover overlapping service periods, eligibility for benefits under these two bills overlaps as well. Consequently, the Post-9/11 GI Bill contains a provision titled Bar to Duplication of Educational Assistance Benefits. This bar clarifies that an individual with entitlements to both Montgomery and Post-9/11 benefits may not receive assistance under 2 or more such programs concurrently, but shall elect under which chapter or provisions to receive educational assistance. A later enacted provision further ensures that an individual may not receive double credit for a single period of service. Rather, he shall elect under which authority such service is to be credited. Thus, to summarize, per Section 3322, service members who are eligible for educational benefits under either the Montgomery GI Bill or the Post-9/11 GI Bill, from a period of service that could qualify for either program, can opt to credit that service toward one educational benefits program or the other. If service members serve for long enough, they may be entitled to both, but such service members cannot receive disbursements from both entitlement programs at the same time, nor may they receive any combination of benefits for longer than 48 months. Outside of those limitations, their service entitles them to the benefits that they have earned, and the VA shall pay them these benefits. When it enacted the Post-9/11 GI Bill, Congress addressed one immediate problem that arose due to the lag time between the start of the Post-9/11 GI Bill's entitlement period and the bill's effective date. The case before us concerns the scope of that solution. As we have explained, the Post-9/11 GI Bill created an educational benefits entitlement for veterans who serve on or after September 11, 2001. But the legislation granting that entitlement was not passed until 2008, and did not take effect until August 1, 2009. Thus, service members who were entitled to Post-9/11 benefits but had been funneled through the Montgomery program until the Post-9/11 GI Bill went into effect needed a way to access the more generous Post-9/11 benefits program. Section 3322D informs these service members that coordination of entitlement to educational assistance under the Post-9/11 GI Bill on the one hand, and the Montgomery GI Bill on the other, shall be governed by Section 3327. Then, under Section 3327, an individual who meets the criteria for Montgomery benefits and Post-9/11 benefits based on the same overlapping period of service can elect to exchange the Montgomery benefits he has received for the post-9/11 benefits that he wants. Section 3327A states that an individual may elect to receive educational assistance under the post-9/11 GI Bill if they meet two criteria. First, they must fall into one of 6 categories as of August 1, 2009, including, as relevant here, individuals who are entitled to Montgomery benefits. Second, they must meet the requirements for entitlement to post-9/11 benefits as of the date of the Section 3327A election. Making a Section 3327A election affects a swap vote. Operation of Section 3327D, an individual making an election under Section 3327A shall be entitled to post-9/11 benefits instead of Montgomery benefits. And, notably, the statute further clarifies that, if the individual has already used some Montgomery benefits when he makes that swap, the new entitlement is not a full 36 months of post-9/11 benefits. Instead, his new entitlement is capped at the number of months of unused entitlement under the Montgomery GI Bill, as of the date of the election. Once a service member elects to swap his Montgomery benefits entitlement for a post-9/11 benefits entitlement, that election is irrevocable. Petitioner James Rudisill spent nearly 8 years on active duty in the U.S. Army, providing 3 distinct periods of military service. He was deployed to Iraq and Afghanistan, experienced combat, and sustained multiple injuries. He reached the rank of captain and earned several medals and commendations, including a Bronze Star. After each period of service, Rudisill received an honorable discharge. In between his second and third periods of military service, Rudisill earned an undergraduate degree. To help finance this education, he used 25 months and 14 days of the Montgomery benefits he was entitled to receive due to his first period of service. After graduating in 2007, he re-enrolled in the Army for a third period. By 2015, Rudisill successfully sought admission to Yale Divinity School. He intended to earn and use that degree to become a chaplain in the Army. To fund his graduate school education, Rudisill applied to the VA for post-9/11 benefits, relying on the entitlement that he had earned with respect to his second and third periods of service. But the VA issued a certificate of eligibility stating that Rudisill was only eligible for 10 months and 16 days of post-9/11 benefits, the length of his unused Montgomery benefits. This response did not accord with Rudisill's understanding of the scope of his entitlement. In his view, he had earned an entitlement to 36 months of post-9/11 benefits based on his second and third periods of service, and he could use 22 months and 16 days of that post-9/11 entitlement due to Section 3695's 48-month aggregate benefits cap. Rudisill filed a notice of disagreement with the VA, which eventually denied his claim for the additional entitlement. The Board of Veterans' Appeals affirmed the VA's decision, but the Court of Appeals for Veterans Claims reversed. It reasoned that although the statutory scheme was ambiguous, the statutory structure, regulatory framework, congressional purpose, and pro-veteran canons supported Rudisill's interpretation of the statute. Over a dissent, a panel of the Federal Circuit agreed, holding that veterans with multiple periods of qualifying service are not subject to Section 3327D2. The en banc Federal Circuit then considered the matter, and, overruling the panel in a 10-2 decision, it reversed. It explained that, when Rudisill sought to use his post-9/11 benefits, he had made an election under Section 3327A, 1, making his benefits subject to Section 3327D2's limit. We granted certiorari and now reverse the judgment of the Federal Circuit. The question before us is this: when service members have separate entitlements to both Montgomery and post-9/11 benefits, can they use their benefits in any order, up to Section 3695's aggregate 48-month cap? In the government's telling, a veteran in this position is subject to Section 3322D's mandatory coordination clause to receive any post-9/11 benefits. He must make an election under Section 3327A, which subjects him to Section 3327D2. By contrast, Rudisill argues that he already has 2 separate entitlements to benefits, 36 months under each program, so Section 3322D does not apply to him. And, even if it did, Rudisill says, Section 3327A's election mechanism is optional, and he does not forfeit any entitlement by declining to make a Section 3327A election. As explained below, the pertinent statutory text resolves this dispute in Rudisill's favor. Section 3327D2's limit applies only to an individual who makes a Section 3327A election. But Rudisill never made an election under Section 3327A, nor must he have done so, because Section 3327 is triggered only if a service member is coordinating an entitlement per Section 3322D. Someone in Rudisill's situation who just uses one of his 2 entitlements is not coordinating anything. This view is further reinforced by our reading of Section 3327A. That provision's election mechanism is optional, and Rudisill does not forfeit his entitlements by declining to make a Section 3327A election. We start by examining Rudisill's benefits entitlements generally. It is undisputed that Rudisill earned two separate entitlements to educational benefits due to the length of his military service. Based on his first period of service, he became entitled to Montgomery benefits, as the statute clearly states. Equally clear is that his second and third periods of service entitled him to post-9/11 benefits. So, from the outset, we know that Rudisill earned two separate benefits entitlements, one per the Montgomery GI Bill and the other per the post-9/11 GI Bill, by serving in the military for nearly 8 years over 3 separate periods. Notably, our analysis does not focus on his periods of service. Rather, what matters is that his lengthy service conferred two separate entitlements. Recognizing Rudisill's separate entitlements leads us to two observations. First, the statute establishes a baseline rule that, absent some other limitation, the VA must pay a veteran's benefits. The Montgomery GI Bill requires that the Secretary shall pay to each individual entitled to Montgomery benefits who is pursuing an approved program of education a basic educational assistance allowance. Likewise, the post-9/11 GI Bill states that the Secretary shall pay to each individual entitled to post-9/11 benefits who is pursuing an approved program of education the amount specified. Second, Congress has clearly and plainly delineated certain durational limits on these benefits entitlements. Montgomery and post-9/11 entitlements have specified outer limits. Each program entitles the recipient to up to 36 months of benefits, and both are subject to Section 3695, which imposes a 48-month aggregate benefits cap. The benefits entitlements are likewise qualified by certain enumerated exceptions. Thus, even before turning to the statutory provisions that are most directly implicated here, it is clear that 1. Rudisill is separately entitled to each of two educational benefits, and 2. Absent specified limits, the VA is statutorily obligated to pay him 48 months of benefits. As explained below, no statutory constraint prevents Rudisill from accessing his benefits, up to 48 months, in whichever order he chooses. Section 3322D is the first of two statutory provisions that are at the heart of this dispute. That subsection, titled Additional Coordination Matters, states, in the case of an individual entitled to educational assistance under the Montgomery GI Bill or other specified programs, or making contributions toward the Montgomery program, as of August 1, 2009, coordination of entitlement to educational assistance under the post-9/11 GI Bill, on the one hand, and such chapters or provisions on the other, shall be governed by Section 3327. There is no dispute that subsection D applies to a service member who is entitled to Montgomery benefits but has become eligible for post-9/11 benefits for his period of qualifying service, as of August 1, 2009, given the overlap of those two entitlement programs. But in the context of the instant dispute, the government argues, and the dissent echoes, that an individual who had two separate benefits entitlements under the Montgomery and post-9/11 bills must also coordinate those two entitlements under Section 3322D in order to access his post-9/11 benefits. We conclude that the plain text of Section 3322D does not support that assertion. First, nothing in the statute imposes a duty for any veteran to coordinate entitlements in order to receive benefits. Sections 3011 through 3014, which outline the Montgomery entitlement, do not refer to coordination, nor do Sections 3311 through 3313, which establish the post-9/11 benefits entitlement, and Section 3695, the provision that specifically addresses veterans with more than one entitlement, does not require, or even mention, coordination. For the person covered by Section 3322D's coordination requirement, the provision does discuss coordination of entitlement to benefits, but the statute distinguishes between entitlement to and receipt of benefits. For example, Sections 3322E, F, and G bar duplicative receipt of benefits. Similarly, Section 3322A says that a service member may not receive two benefits at the same time. But Section 3322D does not concern the receipt of benefits. That term appears nowhere in that subsection. Instead, subsection D addresses coordination of entitlement. Rudisill has no need to coordinate any entitlement. He is already entitled to two separate benefits. Section 3322D says that coordination of entitlement shall be governed by Section 3327. But, as Rudisill correctly observes, with nothing to coordinate, Section 3327 does not govern. Both the government and the dissent argue that this view misconstrues the meaning of the term coordination. In their view, coordinating an entitlement is not converting or exchanging entitlements. But what then does it mean to coordinate an entitlement under this statutory scheme? They contend that coordination refers to a veteran choosing which entitlement he would like to use. But choosing an entitlement is an election, not coordination. and the statute uses the word elect repeatedly to say that veterans should choose between two different entitlements. Here, Section 3322D speaks of coordination, not election, and we generally presume differences in language like this convey differences in meaning. Nor does the reference to coordination in subsection D exist in isolation. Rather, subsection D points to Section 3327, which tells us what coordination means: making an election that permits the individual to get post-9/11 benefits instead of Montgomery benefits. In ordinary parlance, if a person who is directed to coordinate receives one thing instead of another, that coordination is understood to affect a swap. If we were left with any doubt that Section 3322D simply does not speak to a veteran who just wants to use one of his two separate entitlements, two additional clues would tip the balance. First, Section 3322 is titled Bar to Duplication of Benefits. There is no duplication for someone in Rudisill's situation. He earned each benefit separately, and he is asking to receive each benefit separately. Section headings supply cues as to what Congress intended, and Section 3322's heading tells us that its provisions prevent double dipping, something that Rudisill is not doing. Second, Section 3322D applies to individuals with Montgomery entitlements as of August 1, 2009. The government says that this language just references the bill's effective date. But, in the entire post-9/11 GI Bill, only two statutory provisions, Section 3322D and Section 3327A, one specifically reference this date. Why would Congress refer to the effective date of the post-9/11 GI Bill in only these two places and nowhere else? The most logical inference is that this date is material to the work of those particular provisions, and under the interpretation we adopt today, August 1, 2009, is highly relevant, because before then, individuals could have been accruing post-9/11 benefits, ever since September 11, 2001, but would have had no way to opt into that benefits program. The swap Congress devised in Section 3327 gives such individuals a mechanism for accessing these benefits. The invocation of the bill's effective date in Section 3322D thus provides another clue that these provisions are not relevant to someone, like Rudisill, who has no need to make a swap. Adding all this up, we come to the conclusion that Section 3322D serves a specific function: to allow individuals with Montgomery benefits who would prefer to swap them for post-9/11 benefits to coordinate these entitlements via Section 3327. But when a person already has two separate entitlements and simply uses one after the other, he is not coordinating anything. Because that is Rudisill's situation, Section 3322D does not speak to him. Based on the analysis we have already laid out, Rudisill never reaches Section 3327 when using his benefits, because he is not coordinating his entitlements. And the contention that Rudisill can only use his post-9/11 benefits by invoking Section 3327 is contradicted by the text of Section 3327 itself. We cannot agree that, to receive post-9/11 benefits, a service member in Rudisill's situation must elect them via Section 3327. The statute simply does not say that a service member with more than one entitlement receives post-9/11 benefits only by making a Section 3327A election. To start, a Section 3327A election is optional. An eligible individual may elect to receive post-9/11 benefits. The word may clearly connotes discretion. So a veteran can opt for a Section 3327A election, but he does not have to. If he decides not to opt for a Section 3327A election, nothing in Section 3327, Section 3322 or anywhere else purports to alter his entitlement. Instead, the veteran remains in the exact same position as before. A veteran who had only Montgomery benefits is left with only Montgomery benefits. Likewise, for the veteran, like Rudisill, who started out with both Montgomery and post-9/11 benefits, both sets of benefits remain. To argue that Rudisill may receive post-9/11 benefits only by making a Section 3327A election, the dissent invokes and misreads Section 3322A. To repeat, as relevant here, Section 3322A provides, an individual entitled to post-9/11 benefits, who is also eligible for Montgomery benefits, may not receive assistance under both programs concurrently, but shall elect, under which chapter or provisions to receive educational assistance. As is clear from its text, Section 3322A just says, and means, that a veteran cannot use Montgomery and post-9/11 benefits at the same time to fund his education. Section 3322A bars double dipping. It does not impose a substantive requirement to elect benefits via Section 3327A. So, while Rudisill must make an election per Section 3322A when he wants to have a particular aspect of his education funded, it does not follow that he must also make an election under Section 3327A. The two elections are completely different, and making one is not the same as making the other. By blurring all elections into one, instead of recognizing that the statute contemplates multiple distinct elections, the government and the dissent make a crucial misstep. In this regard, it is noteworthy that Section 3322A does not mention, much less cross-reference, either Section 3322D or Section 3327. Even though Section 3322A and Section 3327A both use the word elect, nothing in the text of either provision suggests that these two elections are one and the same. Rather, to elect just means to choose, and that says nothing about the substance of any option. Other parts of the statute confirm that not all elections are the same. For example, Section 3322A requires a person with two or more entitlements to elect which to receive at any given time, while Section 3322H bars duplication of eligibility based on a single event or period of service, and thus requires certain individuals to elect under which benefits programs their service is to be credited. Turning to Section 3327 subsection A, similarly allows a person who is entitled to Montgomery benefits to elect to receive post-9/11 benefits under certain circumstances, and subsection C1 lets a person elect to revoke an entitlement that he previously transferred. Furthermore, and importantly, subsection I refers to these two elections separately. In the context of a statute that establishes multiple distinct elections, attempts to equate a Section 3322A election with a Section 3327A election are unpersuasive. Undeterred, the government turns to Section 3327D, which details the consequences of making an election under Section 3327A. But the plain text of Section 3327D makes clear that the provision does not limit a service member in Rudisill's situation. From its start, Section 3327D contradicts the government's reading of the statute. Section 3327D, 1, tells us that an individual making an election under Section 3327A shall be entitled to post-9/11 benefits instead of basic Montgomery benefits. In other words, he swaps out his entitlement to Montgomery benefits for an entitlement to post-9/11 benefits. Rudisill had no need to get post-9/11 benefits instead of Montgomery benefits because he was already entitled to both benefits. For veterans who have used some but not all of their Montgomery benefits, Section 3327D, 2A lays out one further consequence of making a Section 3327 election. When these veterans make an election under Section 3327A, the number of months of post-9/11 benefits shall be the number of months of unused Montgomery benefits as of the date of the election. Two aspects of this provision stand out. First, like subsection D1, this limitation only applies to an individual making an election under subsection A. So if a person does not make a Section 3327A election, Section 3327D, 2, does not limit his entitlement. Second, this provision makes perfect sense under Rudisill's interpretation of the statute. If a veteran served for 3 years, he earned 36 months of benefits. If he received Montgomery benefits for this service but should have been able to get post-9/11 benefits, due to the overlap in the eligibility for these programs, Section 3327 lets him opt for post-9/11 benefits instead. But if he has already used some benefits at the time he elects the swap, a Section 3327A election does not entitle him to a full 36-month period of post-9/11 benefits, in addition to the Montgomery benefits he has already used. Instead, Section 3327D, 2, ensures that his one period of service entitles him to 36 months of educational benefits in total, no more and no less. By contrast, Section 3327D, 2, is nonsensical under the government's view of the statute. It would impose an exhaust or forfeit requirement for veterans with two separate entitlements. Either use up all of your Montgomery benefits, so that you can get your full 48 months of benefits, or lose any entitlement in excess of 36 months. At the very least, this would be an odd way to create an exhaustion requirement, and the government has not pointed us to any comparable one in this statutory scheme or elsewhere. Again, the more sensible view, and the view that the statutory text best supports, is that Section 3327D, 2, is a limit on exceeding one's entitlement through the swapping mechanism Section 3327 creates, and is thus not an exhaustion requirement at all. In sum, Section 3327A's election mechanism is an optional means of trading an existing benefits entitlement for post-9/11 benefits. Although Section 3327 details the consequences of making that election, those consequences, by their own terms, apply only to an individual who makes a Section 3327A election. On the other hand, the entitlements of a person who does not make a Section 3327A election are not altered. In Rudisill's case, that leaves him with two different entitlements, one under the Montgomery GI Bill, and the other under the Post-9/11 GI Bill, that the VA shall pay to him, subject only to Section 3695's 48-month cap. The bottom line is this: veterans who separately accrue benefits under both the Montgomery and Post-9/11 GI Bills are entitled to both benefits. Neither Section 3322D nor Section 3327 restrict veterans with two separate entitlements who simply seek to use either one. Thus, Rudisill may use his benefits in any order, up to Section 3695's 48-month aggregate benefits cap. If the statute were ambiguous, the pro-veteran canon would favor Rudisill, but the statute is clear. So we resolve this case based on statutory text alone. Because the Federal Circuit incorrectly limited Rudisill's benefits, we reverse its judgment and remand the case for further proceedings consistent with this opinion. It is so ordered. Justice Kavanaugh, with whom Justice Barrett joins, concurring. I agree with the court that the post-9/11 education benefits law entitles James Rudisill, a military veteran, to additional benefits for graduate school. The court goes on to say that the clarity of the benefits law at issue here means that we need not rely on the veteran's canon of statutory interpretation. I again agree. I write separately, however, to note some practical and constitutional questions about the justifications for a benefits-related canon that favors one particular group over others. Under the veterans canon, statutes that provide benefits to veterans are to be construed in the veteran's favor. The veterans canon is a substantive canon of statutory interpretation. A substantive canon is a judicial presumption in favor of or against a particular substantive outcome. Some classic examples include the presumption against retroactivity, the presumption against extraterritoriality, and the presumption of mens rea. Applying a substantive canon, a court may depart from what the court, absent the canon, would have concluded is the best reading of the statutory text. Otherwise, of course, the substantive canon would not be necessary or relevant. In order for a substantive canon to do any work, it must be the case that in the absence of the canon the court would have reached a different conclusion. Substantive canons are typically based on background constitutional principles or long-settled judicial understandings of congressional practice. Because a substantive canon by definition has important decision-altering effects, any substantive canon must be sufficiently rooted in constitutional principles or congressional practices. Here, no one suggests that the veterans canon rests on background constitutional principles. Rather, the canon seems to stem from a loose judicial assumption about congressional intent. In particular, an assumption that Congress intends for courts to read ambiguous veterans benefit statutes more broadly than the courts otherwise would read such statutes. But what is that assumption based on? The court has never explained. The first glimmerings of the veterans canon appeared in the 1940s, but the early cases did not purport to establish a canon. They seem to have simply engaged in broadly purposive interpretation of the particular statutes at issue. Since those early cases, the court has occasionally referred to a general pro-veterans interpretive principle, but without further explanation. The canon appears to have developed almost by accident. Moreover, the veterans canon has apparently not mattered, in other words, has not affected the result, in any of this court's past decisions in veterans cases, or in this case for that matter. The court has rarely applied the veterans canon, and even when mentioned, the canon has seemingly served only as the proverbial icing on a cake already frosted. That is, an extra citation after the court has already concluded that the veteran prevails anyway under the statutory text and traditional tools of statutory interpretation. Despite the canon's seemingly non-existent impact on this court's decisions, the court's reflexive repetition of the canon over the years has created the appearance of deeper rooting, leading lower courts, particularly the Federal Circuit where veterans' benefits cases are channeled, to rely on the canon in a way that this court has not. But this court's repetition of the canon has not yielded any greater justification or explanation by the court for applying such a canon in the first place. In considering whether a sufficient justification exists, we must confront some fundamental problems with benefits-related canons like this one. To begin with, the notion that benefits statutes should be interpreted to favor a particular group creates significant tension with the actual operation of the process by which Congress and the President enact spending laws. To be sure, if someone asked a member of Congress or the President, or this judge for that matter, in the abstract, should veterans get more benefits? The answer would be yes, but that question is not, and cannot be answered in the abstract. The spending process is a zero-sum game, where money spent on one group means less money for other groups and other national priorities. Would Congress prefer to pay for another semester of veterans' graduate school educations, or instead for more Pell Grants for lower-income college students? Would Congress want to spend more on healthcare benefits for the disabled, or instead on prescription drug benefits for senior citizens? Would Congress choose to increase the pension benefits of retired CIA agents, or instead the wages of soldiers who are serving in harm's way today? The list of difficult choices goes on and on. National security, assistance to the poor, law enforcement, energy production, environmental protection, border security, cancer research, housing aid, highway construction, airplane safety, school lunches, disaster relief, drug treatment, prisons, and a plethora of other national priorities all compete for funding in the legislative process. And the U.S. Treasury is not a bottomless well of free money. Rather, the money comes primarily from the taxes paid by the American people. The spending process in Congress requires hard choices with painful trade-offs. Judges have no principled way to make those choices or weigh those trade-offs. Nor do judges have a principled way, other than reading the statutory text as written, to conclude that Congress and the President would prefer to favor one group over another, or stated another way in this zero-sum process, to disfavor one group over another. In addition to that practical problem, judges have no constitutional authority to favor or disfavor one group over another in the spending process. Rather, under the Constitution's separation of powers, Congress and the President make those policy judgments. Courts must then neutrally interpret and apply the spending laws enacted by Congress and the President. Courts do so by heeding the statutory text and employing the traditional tools of statutory interpretation, not by singling out particular groups for favored or disfavored treatment. For those reasons, courts interpreting spending laws usually do not apply canons to favor or disfavor particular groups. Courts, for example, do not apply a low-income families canon, a healthcare for seniors canon, or a local law enforcement canon to favor those groups. Nor, from the other direction, do courts apply a general fiscal responsibility canon to narrowly construe spending statutes. In short, any canon that construes benefit statutes in favor of a particular group, rather than just construing the statutes as written, appears to be inconsistent both with actual congressional practice on spending laws, and with the judiciary's proper constitutional role in the federal spending process. To be clear, Congress's commitment to assisting veterans through the many federal veterans benefits programs is entirely appropriate given the sacrifices made by those who have served in the armed forces. The statutes that provide significant veterans benefits, including healthcare, education, disability, and retirement benefits, properly assist those who have defended America. And when statutes afford broad benefits for veterans or others, as is often the case, courts should apply the statutes as written. But providing federal benefits and determining their scope is Congress's prerogative. The judiciary's role is to neutrally interpret those statutes, not to put a thumb on the scale in favor of or against any particular group. For that reason, it may be important in a future case for this court to address the justification for any benefits-related canon that favors one group over others. Justice Thomas, with whom Justice Alito joins, dissenting. Our country rewards those who serve in the armed forces with educational benefits. This case involves the educational benefits available under the Montgomery GI Bill and the more recent Post-9/11 GI Bill. The Post-9/11 benefits are more generous than the Montgomery benefits, and veterans are sometimes entitled to benefits under both programs. By statute, however, veterans cannot receive benefits under both programs at the same time. Congress therefore created an election mechanism that allows veterans to switch from Montgomery benefits to Post-9/11 benefits. Under that mechanism, when a veteran switches to Post-9/11 benefits after using some, but not all, of his Montgomery benefits, the amount of his Post-9/11 benefits is limited to the number of months he had remaining for Montgomery benefits. The question here is whether this limitation applies to James Rudisill, a retired captain in the U.S. Army. The court agrees that Rudisill could not use his two sets of benefits concurrently, and that he switched to Post-9/11 benefits when he had some remaining Montgomery benefits. But it declines to apply the statute's corresponding limitation on his benefits because Rudisill was separately entitled to Montgomery and Post-9/11 benefits due to his multiple periods of service. Because this approach conflicts with the statute's plain text, I respectfully dissent. Since World War II, Congress has enacted numerous statutes that provide veterans with a range of educational benefits, commonly called GI Bills. Two of these statutes are at issue here: the Veterans Educational Assistance Program Act of 1984, Montgomery GI Bill, and the Post-9/11 Veterans Educational Assistance Act, Post-9/11 GI Bill. As the majority explains, the Montgomery GI Bill had been the primary source of educational benefits since 1985. But, in direct response to the September 11, 2001, attacks and the ensuing conflict, Congress enacted the Post-9/11 GI Bill and made its benefits retroactively available. The Montgomery and Post-9/11 programs differ in meaningful ways. Montgomery benefits provide a modest, fixed monthly stipend, whereas Post-9/11 benefits are more generous and can cover the actual net cost of in-state tuition, along with other expenses such as tutorial assistance and licensing test fees. Both programs impose a durational cap on the benefits that an individual may receive. Regardless of how long a veteran has served or how many periods of service he has, a qualifying veteran is generally eligible for a maximum of 36 months of benefits under each program. In addition, there is an aggregate cap on benefits that applies across programs. No veteran may receive more than 48 months of educational benefits total. The two educational benefit programs cover overlapping time periods, and several statutory provisions address this overlap. No veteran can use the two sets of benefits concurrently. Veterans accordingly must elect which benefits to receive at a specific time. As relevant here, there is a condition attached to one particular election. Under the statute, if a veteran elects to switch to post-9/11 benefits when he is used, but retains unused Montgomery benefits, he is subject to a statutory limitation on entitlement. Under this limitation, the amount of his post-9/11 benefits will be limited to the number of months of unused entitlement of the individual under the Montgomery program. The question before us is whether that statutory limitation applies to Rudisill's benefits. Rudisill served during 3 separate periods, spanning roughly 8 years. He first enlisted in the Army in 2000 and served until 2002. During this period of service, Rudisill became eligible for Montgomery benefits. He used some of these benefits to start and, after a second period of service spanning about a year and a half, complete an undergraduate degree. Rudisill then rejoined the Army as a commissioned officer, serving from 2007 to 2011. Rudisill's second and third periods of service made him eligible for post-9/11 benefits. After he completed his third period of military service, he was admitted to Yale Divinity School. Rudisill sought to use his remaining benefits to fund his graduate education at Yale. At that time, Rudisill had used 25 months and 14 days of his Montgomery benefits for his undergraduate education. This left him with 10 months and 16 days of remaining Montgomery benefits. Rather than use these remaining benefits, however, Rudisill decided to switch to his post-9/11 benefits. As part of that switch, Rudisill filled out a Department of Veterans Affairs (VA) form electing to receive post-9/11 benefits in lieu of Montgomery benefits. He expressly acknowledged that his months of entitlement under Chapter 33I.E. post-9/11 benefits would be limited to the number of months of entitlement remaining under Chapter 30I.E. Montgomery benefits. Applying the limitation on entitlement, the VA awarded Rudisill post-9/11 benefits for 10 months and 16 days, the amount he had remaining for his Montgomery benefits. Rudisill appealed, arguing that the limitation did not apply to him because he had separate entitlements to Montgomery and post-9/11 benefits due to his multiple periods of service. Sitting on bank, the Federal Circuit held that the VA had correctly applied the statutory limitation to Rudisill's benefits. I would affirm. Rudisill's post-9/11 benefits are limited to the amount of Montgomery benefits he had not used. Because he could not use his sets of benefits concurrently, the statute required that Rudisill coordinate his entitlements, and that such coordination would be governed by the statutory provisions. Rudisill then used the election mechanism to switch to post-9/11 benefits after he had used some but not all of his Montgomery benefits. By making that election, the statute limited his benefits to the amount of Montgomery benefits he had left. Because the statutory scheme directs how a veteran in Rudisill's position can switch to post-9/11 benefits, I would apply that mechanism to Rudisill's election and the cost that comes with it. As an initial matter, there is no dispute that Rudisill cannot use his Montgomery and post-9/11 benefits concurrently. Under the statute, a veteran entitled to post-9/11 benefits who is also eligible for Montgomery benefits may not receive assistance under 2 or more such programs concurrently, but shall elect in such form and manner as the Secretary may prescribe, under which chapter or provisions to receive educational assistance. Because Rudisill is entitled to Montgomery and post-9/11 benefits, he cannot receive both benefits at the same time. Instead, he shall elect which benefits to receive. How does Rudisill elect which benefits to receive? That is the core of the dispute in this case. In my view, the statute answers that question by requiring Rudisill to coordinate his entitlements and creating an election mechanism for him to do so. After barring the concurrent use of benefits, Congress included a provision titled Additional Coordination Matters in subsection D. This coordination provision states that in the case of a veteran entitled to benefits under certain other chapters, including the Montgomery chapter, coordination of entitlement to educational assistance under this post-9/11 chapter on the one hand, and such chapters or provisions on the other, shall be governed by this section. The coordination here refers to a veteran choosing which entitlement I.E. set of benefits he would like to use. The ordinary meaning of coordination is the action of arranging or placing in the same order, rank, or degree. In this context, coordination refers to a veteran ordering his sets of benefits. A veteran's entitlement to both Montgomery and post-9/11 benefits necessarily requires coordination, because he cannot use them concurrently, as subsection A prohibits such use, and subsection D explains that such coordination shall be governed by this section. Unsurprisingly, the coordination provision points to an election mechanism. As relevant, under this section, a veteran may elect to receive educational assistance under this post-9/11 chapter if he meets certain criteria. As of August 1, 2009, the veteran must be entitled to Montgomery benefits and meet the requirements for entitlement to post-9/11 benefits. Next, a veteran may make this election to switch to post-9/11 benefits if he has used, but retains unused entitlement under the Montgomery chapter. Put more simply, this election mechanism applies to a veteran who is entitled to both Montgomery and post-9/11 benefits and has used some but not all of his Montgomery benefits. There is a consequence, however, for using this election mechanism. By making an election, a veteran triggers a limitation on entitlement. Under that limitation, the veteran's post-9/11 benefits are limited to the number of months of unused entitlement of the individual under the Montgomery chapter, as of the date of the election. That is, a veteran with remaining Montgomery benefits, who elects to switch to his post-9/11 benefits, is limited to the amount of Montgomery benefits he has remaining. Rudisill is covered by the election mechanism and its accompanying limitation. He is entitled to both Montgomery and post-9/11 benefits, and, as of August 1, 2009, he had used but retained unused Montgomery benefits. This section therefore provided him a mechanism by which he could elect to switch to post-9/11 benefits. And Rudisill made that election. By electing Chapter 33, I acknowledge that I understand. My months of entitlement under Chapter 33 will be limited to the number of months of entitlement remaining under Chapter 30. Because Rudisill elected to switch to his post-9/11 benefits before exhausting his Montgomery benefits, he was subject to the corresponding limitation on his entitlement. He could receive post-9/11 benefits for only the months remaining on his Montgomery benefits. Indeed, the VA informed him of this consequence before he made his election, and Rudisill acknowledged it. Applying this limitation, the en banc Federal Circuit correctly found that Rudisill was limited to 10 months and 16 days of post-9/11 benefits for his graduate education. That straightforward conclusion follows from the statutory scheme that Congress created. I would simply apply that statutory limit to Rudisill. Rudisill and the majority make various attempts at avoiding the statute's inevitable conclusion, but none hits the mark. That is in large part because the statute's text, though complicated, is ultimately unambiguous. Accordingly, they do not dispute that Rudisill earned entitlements to both Montgomery and post-9/11 benefits, and that he cannot use these entitlements concurrently. They do not dispute that he made an election to switch to post-9/11 benefits. And they do not dispute that, when he made that election, he had used, but retained unused Montgomery benefits. Instead, Rudisill's primary argument is that the specific provisions in the statute governing coordination and election do not apply to veterans who have multiple periods of service. But Rudisill acknowledges that the text of this section does not state that its election mechanism is limited to veterans with only a single period of service. There is likewise no language in the coordination provision that plainly cabins its application based upon periods of service. Because the plain text contains no carve-out based on periods of service, that should be the end of the debate. Rudisill's contrary argument is especially unconvincing, given that Congress included other period of service limitations in the very subchapter at issue. Congress provided that a period of service counted for purposes of an education loan under a different program may not be counted as a period of service for entitlement to educational assistance under this post-9/11 chapter. Congress could have chosen to similarly limit the scope of the coordination provision or the election mechanism based upon periods of service or separate entitlements, but it did not. We cannot do so of our own accord. Next, Rudisill contends that the election mechanism in Section 3327 is merely meant to provide veterans with a single period of service, a way to convert lesser Montgomery benefits into more generous post-9/11 benefits on a one-to-one basis. The text of Section 3327 makes clear, however, that it is a mechanism for making an election to switch from Montgomery benefits to post-9/11 benefits, not merely a way to convert one into the other. Section 3327 provides how a veteran may elect to receive post-9/11 benefits instead of his Montgomery benefits. And it echoes Section 3322A's requirement that a veteran entitled to multiple sets of benefits shall elect which benefits to receive because he cannot use them concurrently. Moreover, the election mechanism applies only to veterans who are already eligible for both programs. Because a veteran must already qualify for post-9/11 benefits, this mechanism cannot provide a way for veterans who lack post-9/11 benefits to convert their Montgomery benefits. Indeed, the entire point of the election mechanism is to coordinate Montgomery and post-9/11 entitlements I.E. to manage two existing entitlements. More importantly, Section 3327A does not cabin its application based upon period of service or separate entitlements. Rudisill's interpretation ultimately does not overcome the application of Section 3327's plain text to his circumstance. He is entitled to both sets of benefits and switched to post-9/11 benefits when he had used, but retained unused Montgomery benefits. The majority, for its part, takes a different tack. Its reasoning seems to rest on the theory that because Rudisill was entitled to Montgomery benefits and entitled to post-9/11 benefits, those multiple entitlements cannot be limited when switching between benefits. But the majority's own reasoning undermines that theory. It agrees that Rudisill cannot receive the full 72 months of benefits he earned, because a separate statutory provision limits him to 48 months total. And it agrees that Rudisill cannot use his two separate entitlements concurrently. This is true even though Rudisill is entitled to 36 months of Montgomery benefits and entitled to 36 months of post-9/11 benefits. In other words, the majority itself admits that Rudisill's entitlements are not absolute. But while the majority accepts certain statutory limitations on Rudisill's multiple entitlements, it rejects others, even ones listed in the same subsection. Indeed, even though the court agrees that some election must be made, it rejects the election process spelled out in the statute to address Rudisill's circumstance. My focus on this election does not blur all elections into one, but rather applies specific statutory text that plainly covers Rudisill. The majority tries to justify its selective reading of the statute by suggesting that the coordination provision in Section 3322D simply does not speak to a veteran who just wants to use one of his two separate entitlements, but that provision specifically governs the coordination of entitlement to post-9/11 benefits on the one hand and Montgomery benefits on the other. It is unclear how a statute could more explicitly cover the interaction between two separate entitlements. The majority also provides no satisfactory answer for why the concurrent use bar in Section 3322A applies to Rudisill, but the coordination provision in Section 3322D does not. Both provisions cover veterans who qualify for both sets of benefits, yet the majority applies one but not the other to Rudisill. More fundamentally, the court agrees that some election must be made. Rather than leave Rudisill to make some uncodified election to switch to post-9/11 benefits, I would apply the election mechanism that Congress created to cover his circumstance. The majority's remaining arguments are simply critiques of Congress's policy judgments. The court calls the government's reading of the statute's election mechanism nonsensical because it requires a veteran to exhaust or forfeit his Montgomery benefits before switching to post-9/11 benefits. But, in reality, the election mechanism offers a veteran in Rudisill's circumstance two paths. He may use 48 months of benefits by first using all 36 months of his Montgomery benefits, followed by 12 months of post-9/11 benefits. Or, he could use 36 months of benefits, with his choice of when to switch from Montgomery to post-9/11 benefits. It is not remarkable for Congress to include a rule allowing individuals to make a wholly voluntary election to receive a more generous benefit earlier, at a cost. In any event, the wisdom of this limitation is not up to this court. It was for Congress to decide what post-9/11 benefits a veteran should receive retroactively. As Rudisill acknowledges, the post-9/11 program is far more generous and, accordingly, costs much more than the Montgomery program. Perhaps the limitation on entitlement reflects a measure to manage this growing cost, given that passing a law often requires compromise. Or, perhaps not. Either way, the limitation is what Congress enacted, whether the majority agrees with its fairness or not, and the text that Congress enacted must dictate the result in this case. Moving even further away from the text, the majority hints that the veterans' canon could apply if the statute were ambiguous. The veterans' canon directs that interpretive doubt is to be resolved in the veteran's favor. Yet, as the majority recognizes, this canon cannot apply when the statutory text is plain, so it has no role to play here. More importantly, substantive canons such as the Veterans Canon rest on uncertain foundations. I share Justice Kavanaugh's concern that the Veterans Canon appears to have developed almost by accident, and no explanation has been provided for its foundation. I question whether this purported canon should ever have a role in our interpretation. The court holds that, although Rudisill must make some election to switch from his Montgomery to post-9/11 benefits, the statute's corresponding limits do not apply because it would reduce the amount of available benefits. In my view, the court ignores the statutory mechanism that Congress created in favor of an interpretation that reaches a desired outcome. I respectfully dissent. Thanks for listening. This podcast is not affiliated with the United States Supreme Court or its staff in any way. The summary of this opinion given in the introduction was taken from the summary provided at oyez.org. Any mistakes in the opinion you just heard should be attributed to this podcast. If you would like to support my efforts to make Supreme Court opinions available to the public, please subscribe. Thank you.